Well, Nick Freeman is a criminal defence lawyer at Freeman and Co. Solicitors. He's known in the tabloid press as Mr. Loophole for getting various celebrities and politicians off driving offences. Nick, very good evening to you. Well, first of all, I think you have defended Katie Price in the past successfully when she was accused of using a mobile phone while driving. When somebody has a driving record like hers, should it be an automatic throwing of the book?
No, look, every case is looked at, as you rightly say, on its own merits. What's important to bear in mind is that there are sentencing guidelines. These were revised, the last ones were revised in 2017. So the idea is that there is a level of consistency throughout the country in terms of how defendants are sentenced. And the courts look at a whole variety. It's a bit like painting by numbers, to be quite honest with you. It's not quite as robotical as that. But there is a system in place and you follow it through and you should arrive at the right result. And in this particular case, the judge's hands were actually tied. You indicated that you thought maybe because she was a celebrity that she was dealt with in a certain way, or maybe because she had Harvey, who, as we know, is a disabled boy or an adult now. That actually wasn't the reason. The reason was when she first appeared in court, I think it was on the 29th of September, the court, the magistrates, and it was a lay bench at that time, and I'm not making any criticism, I'm just simply stating that they were persuaded to defer sentence. And what that means is that they were told by the lawyer, please do not sentence her now, but adjourn this case because my client has a serious medical problem. She needs urgent treatment and she is going to book in. And in her case, it was the Priory, and we've heard the price of the Priory, and the court was persuaded to defer sentence. And they agreed to defer on two conditions. One, that she checked in at the Priory, and two, that she didn't commit any further offences. So provided she complied with those two conditions, the judge's hands today were tied, and she acknowledged that. I think she basically said, I would love to give you an immediate custodial sentence, but because sentence was deferred, you've complied with those two conditions, you have in law what's called a legitimate expectation that you would not receive an immediate custodial sentence. And that is the reason that she is not spending Christmas behind bars or in an open prison, and for no other. I do feel that had the court not been persuaded back on I think the 29th of September, she would have without question received a short, sharp shock today, and she would have been incarcerated over Christmas to teach her a lesson, because as you've rightly outlined what the judge said about her driving record and about her behaviour. But so that's why we are where we are today. And so, some people will say, look, she deserved to go to prison. The court were perfectly entitled to defer sentence, and the court always has a job. It's to combine the sort of punitive and remedial aspects of sentence. So on one hand, we want to punish, but on the other hand, if we can help someone and get them, out of the trouble they're in, and she clearly has problems, then that's probably a path that should be explored. And I'm sure many of your listeners are saying, well, how many chances does she have? And I think she's in the last chance saloon now. I think, first of all, she's avoided immediate custody. She's got 100 hours unpaid work to do for the community. She's disqualified from driving for 2 years. She's also got a suspended sentence. If she breaches any aspect of the sentence that she's received today, she will be back before the court. All bets are off, and she will have a legitimate expectation to receive an immediate custodial sentence. That 16-week period of custody that's suspended for 12 months will kick in straight away. So there's a sort of Damocles hanging over her now for 2 years, because we know from her record that she's driven whilst disqualified. And it's interesting to note that that the courts and the police are always criticised for not doing their job properly. This lady, and brought her before the court very promptly the next day, or in fact that day. I think she was arrested at 6 o'clock in the morning, 6:30 in the morning. The sentencing guidelines have been altered now. And, for just disqualified driving, prior to 2017, you would expect to receive an immediate custodial sentence. That would be your legitimate expectation. But now they've been softened. Not long, probably a short, sharp shock. If you pleaded guilty, maybe 4 weeks, 6 weeks, of which you do half, but you would have your liberty removed, and that's I imagine a horrendous experience. But now they've been softened, and certainly for the first offence, you're not going to go to prison. That's literally a racing certainty. So what's happening is the sentencing process has actually been softened, and that's to do with society and our approach to criminality. We live in a society now where there aren't many police on the streets, and many offences, many were quite serious offences, are not dealt with a police investigation. You might have,
But have the
fraud
sentences
isn't
been...
dealt with by the police. So, sorry, go on, carry on.
sorry to interrupt, but have the sentences for drink driving been softened as well?
That they haven't really been softened. No, they haven't really been softened. That they remain more or less the same as they are.
And what's the maximum sentence you can get for drink driving?
6 months. 6 months. And of course, but she pleaded guilty, so the sentence is automatically reduced by a third. So if the court wanted to throw the book at her, bearing in mind there are aggravating features here, there's an accident, there's a bad record, there was drugs involved, and even though she was charged with a drug offence, the Crown agreed to dismiss that at the first hearing because she pleaded guilty to the drink drive. It nevertheless is an aggravating feature that she swiped. There was a positive cocaine sample taken at the roadside. These are all aggravating features. I don't know what the reading was in this case. No one seems to mention what the reading was. And the way courts look at drink driving is they look at the levels of reading, and there are scales depending on how high that is. And certainly at the sort of higher levels, then custody is recommended. In the lower intermediate levels, it's either a fine or it's a community penalty. So it's only at the very highest levels that you can expect to receive custody. I don't know what the reading was in this particular case, I have to say, and I also don't know when the disqualification period that she breached was imposed. Obviously, if you breach it very quickly after it's imposed, that makes the matter much more serious, because it's a court order. When a court disqualifies you, it's a serious situation. You're being told by the law of the land, you must not drive a car, and if you do, there's no insurance, and you flout that. That you're basically sticking two fingers up to the court, and the courts, as I said before, would deal with that prior to 2017, probably with immediate custody. But now we've gone soft. That's the system.
Okay. Nick, we have to leave it there. Thank you so much for joining us. Really appreciate your time.